But I wanted to stop and take a moment before I talk about the rest of the Ash and Trash 400 rules today to see if there are any lingering evidentiary concerns. In other words, I mean issues within evidentiary law that in your head you just feel a massive confusion about and you would appreciate extra review over concerning the next 2 weeks. And you can't say all the rules because that doesn't help me any. Yes?
I have a stupid question, but is there, for character evidence, is there a list of the types of character evidence? Because a lot of times I think when I see something I'm like, oh, that could be character evidence, but in my mind I think of character evidence in more broad, vague terms like peacefulness, aggressiveness.
Well, character evidence can be something as peacefulness, aggressiveness, honesty. Think of it as a personality characteristic. The trick is that there's not a definitive list, but instead you are supposed to look at the required elements of the crime or the potential affirmative defenses that might be raised. And from those elements, you're supposed to extrapolate which character traits might be most relevant. Now, in crimes that involve violence, those are easy, right? Character for peacefulness, character for lack of peacefulness, or character for violence. In crimes that involve fraud, character for truthfulness. Where it gets a little bit more problematic, what if I have a criminal trial where the issue is child abuse? Well, if they were a loving father, if they had a reputation of being a great parent, that character trait of being a great parent or being a loving father or a loving mother might be considered a pertinent character trait. You should think of it this way. The cause of action defines a relatively narrow legal question that's being answered, right? Then I extrapolate out from the legal question to what potential character traits might make a fact of that cause of action more or less likely to be true, right? And so that's why it's both broad and narrow at the same time. On the bar exam, most of the time, if you're looking at character and it's not truthfulness, it often comes out as an issue of violence or peacefulness. Why? Because there are so many common law crimes that deal with violence. But there are some that don't. There are some that deal with fraud. And on the civil side of the arena, you just simply need to memorize the ones that I've mentioned previously. And you need to be able to identify them when they come up. Defamation and libel, negligent hiring, child custody cases, and marriage. Divorce. Why? Because in those instances, character may be relevant. Now, divorce is not as common anymore. Why? Because most states are what now? No-fault divorce states, which means it really doesn't matter if you were a philandering cad. It doesn't affect the divvying up of the property. The property is divvied up based upon some statutory guidelines, regardless of your peccadillos while you were married, right? And that's an interesting area, but at the common law it was. So you're really going to have to read the question. And in fact, your ability to read the question and identify the cause of action and connect it to a pertinent character trait may very well be dispositive as to whether or not you can answer a character question correctly. Because if there's a connection and you don't see it, you're going to give me the wrong answer. And that's not something that I can fix for you. It's one of the reasons that I recommend you do a lot of questions in preparation. Today's what? The 7th of April? A month from today, you'll be taking my exam. I think, no wait. Yeah, I believe it's the 7th of May. Yeah, so you've got a month. You've got all the time in the world. You've got all the time in the world. No, you don't, but you've got enough time if you do the work. So that's the thing on character. I would really suggest to you now that I've lectured about character a couple of times, and you've had a lot of materials. You really need to do some multiple choice questions in the character arena while that's fresh in your head, and then you'll know whether or not you've got it. And then I want to give you a test preparation technique for you to think about. Some of you may have bar review courses that you've paid for and that you've received the books for. You may also have access to online materials as a result of that, question banks. Those things do a really neat thing for you. they not only identify how you perform on the multiple choice questions that you practice, they also identify areas of strength and weaknesses. So, for example, you take a 50 multiple choice evidence test from your bar provider, your bar preparation provider, and you miss all the character questions, you know you've got a character weakness. On the other hand, if you miss the hearsay or if you miss the impeachment, you can identify your weak areas. And this lets you focus your studies in those weak areas. Now, again, this is something that only you can do for yourself, but if you do it, it will pay very large dividends because it can be very helpful to you. But what it requires is for you to carry that water, because it would be literally impossible for me to do it in class. I mean, because you're in the tethered evidence class, and because, quite frankly, no offense, because you're a part-time class, and I know the demands that are on your time, and I know how hard this subject is to learn, I have structured this course this semester where you have 3 weeks of substantive law given back to you at the end. And I've done that on purpose because I want to make certain that I can maximize those of you who are part-time students, your ability to be successful. Experience tells me that we will have a lot of luck with that, but only if you do the work that I've suggested that you do. If you don't do the work, it's not going to help you any. You'll still be kind of lost. Yes?
We're going to have an additional practice class?
I don't intend to give you another multiple choice test at this time, although we'll see how the timeline goes. I might be able to, in the last week of class, give you another 5 or 10 questions. But I haven't committed that yet. I'm going to wait and see how we do. Yes, Alejandro?
Are you going to upload the PowerPoints that
I will put them up at some point, but if you would go and look at, I don't know, do you guys have access to previous evidence classes that I have on the blackboard? You can't see them? Okay. Because those used to be accessible. I will put them up. But I'm telling you right now, if you watch the way I teach, the PowerPoint slides are what? There are 3 or 4 bullets that identify the topic that I want to talk to you about. They are nothing more than the outline to make certain that I cover the material. The PowerPoints themselves are not going to even remotely help you study for the test. It's just not going to get you there. But I'll put them up. You had a question.
I did. Actually, it was in regards to if there has been a prior allegation that was or was not adjudicated by the court, and you were talking about this last class, and you had mentioned that there was a test to determine whether or not that can come in. I may have missed it. I just was hoping that maybe you might touch on that a little bit.
That was the 4-prong test that I talked about at the end of class, where we use 104, the judge's ability under 104 to consider the evidence, applying a 403 balancing test. And when the judge looks at the evidence to determine whether or not it's going to be admissible under 104, the question is whether or not a jury might find that it exists, right? For 104. But then when you get to the balancing test as to whether or not to let in the 404B type evidence, the judge has got to say that a notional jury could find by a preponderance of the evidence that that fact occurred, right? And we talked about why we need to have this test, because in some cases the only evidence that the state, because it's usually the state who's the proponent of that type of stuff, the only evidence they might have would be the statement of a witness. And if all they have is the statement of a witness and there's nothing else there, the judge says, well, could a jury listening to this witness find by a preponderance of the evidence that that earlier act occurred?
That's the burden of proof extrinsic acts test.
Extrinsic access for 404B type evidence. And that's a particular type of thought process that the judge goes through, which is not present in 104, it's not present in 105, and it's not present in 403 or 404. But the case law takes those 4 rules, puts them together, and that's the way the judge is supposed to reason through issues of character like that. And that's very helpful for us to know as trial lawyers, right? Because if we understand that, then we can work out what we do or do not need to do from a proof perspective. Let's look at 406 really quickly. Yes?
A question piggybacking off of that. So according to my notes, after you do that test, that then applies the limiting instruction under 105?
But it's not required unless you request it.
Okay, good. So I got that.
And to dig even a little further into what we talked about last time, that limiting instruction under 105 in the federal system can be given at any time. In the Florida system, it must be given contemporaneously with the evidence admissibility. Cool. All right, 106. Yes, sir. 406. Routine practice. The things I want you to remember about 406 is the magic language of always, invariably, habitually. It's got to be something that occurs at an almost subconscious or unconscious level that happens all the time, and there's no requirement for corroboration. But it's a very narrow area. It doesn't require a decision-making process to have it happen. So, for example, we have a guy who's involved in a car accident, and he sues the driver of the other car, and the driver of the other car alleges negligence on the part of the plaintiff because the plaintiff didn't have his seatbelt on. A classic fact scenario. If the plaintiff has someone who's ridden to work with him for the last 2 years, and who has always seen him wear his seatbelt, and who will testify, he won't drive the car unless everyone's seatbelt is fastened. He invariably will not drive the car unless that happens. That would be a classic example of habit evidence to argue that he had his seatbelt on the day that the accident actually occurred. And from a multiple choice standpoint, this is an easy reading comprehension type question. We look for the words that are the equivalent, meaning-wise, of habitually. And it's usually invariably, without fail, all the time, something like that. Alejandro.
Is this really important in trial, like this kind of evidence, or they are just, because I would think as a juror that maybe that time he wants it.
It's important in trial from the standpoint of that may be all the evidence that I potentially have to prove a particular element. The judge doesn't allow it, it's not coming in. Then you just, that becomes an argument to the jury. Do any of you have habits that you always engage in?
The way I towel off in the shower.
Some people are like that. Some people are OCD to the point of how I put my toothpaste on my toothbrush. I wet the toothbrush twice. I do exactly 1/4 inch of toothpaste. I wet the toothpaste again. I shake it 3 times and put it in my mouth. I know that sounds a little crazy. I'm not saying I do that, but bugs. Oh, look, a squirrel. Little ADD. All right, so that's 406 habit. That's relatively easy. 407, subsequent remedial measures. The thing you need to remember about subsequent remedial measures is that I can't admit it if I want to prove these 4. These are the exceptions. If that's the reason that the party is offering the subsequent remedial measure, it's never going to be admissible. But when will subsequent remedial measures always be admissible? To show ownership or control when ownership or control has been denied. And I've used a little scenario of the guy who runs the petting zoo with the goat. That little scenario is a great way to test subsequent remedial measures, offer to pay medical expenses, and offers to compromise. Because it's all about the timeline. When I look at 407, 408, and 409, it's all about the timeline of what was said and when it was said. And because those 3 rules lend themselves very easily to a timeline-specific analysis, they often show up as multiple choice questions on the bar exam. Why? Because it's easy to see whether or not you know the black letter law. But because 408 and 409, talking about offer to pay medical expenses and offers to settle the case, can often interact because medical expenses are sometimes as the result of litigation, they work very well to confuse students. And so I'm telling you right now, you will see questions from 407, 408, and 409 on your exam. I've gone over those in class quite a bit, just to remind you, when I'm dealing with compromised offers and negotiations under 408. The thing that we look for is whether or not there is pending litigation. If I make an offer to settle something and litigation is not yet pending, that offer, when it accompanies a potential admission of responsibility, is going to be admissible at trial. If, however, I make the offer after litigation is pending, it's not going to be admissible under 408 unless I lie about it, and then it's going to be admissible let's find the words here. For bias, whoops. I'm using my size 15 finger to highlight tonight, and that's a problem.
You need a,
No, I'm good. I'm good. It's going to be admissible for bias, prejudice at the bottom of the rule, but I want to point something out to you at the very top. Okay. I cannot offer it to prove or dispute the validity or amount of a claim, or to impeach by prior inconsistent statement or contradiction. Why is this important for you? Because you've learned that prior inconsistent statements are routinely admissible from an impeachment perspective, and they are, when it's going to the credibility of the witness. But if I am impeaching with a prior inconsistent statement having to do with an offer to compromise or settle the case, that doesn't go to credibility. Why? Because we presume, as part of the process of negotiation to compromise, that we will say and agree and admit to things that are, quite frankly, not true, just to settle the case. And because we want to drive settlement at the private civil level, we're not going to hold you accountable from a credibility truth perspective for anything that you say to try to make the case go away. I think of this in my head as the, hey, we don't care what lie you tell as long as you get this issue settled. So all the, oh, I'm so sorry that I ran into your yard. I'm so sorry of the trauma that you experienced when you saw me shooting squirrels in my backyard. I know the mental injury that you suffered is so great. It's my fault. I never should have done it. Please let me pay your No, let's not use that. Please let me give you some money for your pain and suffering. And I've just admitted to all this horrible conduct. And then you decide to sue me anyway. And I take the stand and I say, well, I didn't do any of those things. I never said a word to her. I don't know what she's talking about. Normally, it would be a prior inconsistent statement. But because of the policy desire to push us toward settlement, it's not in this particular set of circumstances. Why do I point it out to you? Because your natural inclination, having been in evidence class now, is to think I can always impeach with a prior inconsistent statement. This is the exception to that particular rule. Yes?
Does it matter if it's like court-ordered negotiation or court mandated, so it's in the middle of litigation?
Negotiation is negotiation, as long as it's a negotiation. So it doesn't matter if it's binding arbitration, if it's court-ordered mediation, or I'm just trying to talk and make the thing go away. Yes?
Question on the definition of litigation pending. Does that mean, could I just say, I'm going to sue you?
Yes.
And, is that litigation now pending?
From the standpoint of the way the National Conference of Bar Examiners considers it on a bar review question, anything within the call of the question that indicates an intent by one of the parties to engage in legal action. So, for example, something as simple as child gets injured at an amusement park, the amusement park owner comes up and says, what can I do? And the father looks at him and says, I'm going to own your park. What is that an indication of? That's an implied assertion that I'm going to sue you. That would be sufficient for purposes of this rule. Now, they draw that line that brightly on the multi-state bar examination. In the real world, that would be a case law determinative question, wouldn't it? You would go and look and see what had been considered truly litigation has defined within your jurisdiction. But for your jurisdiction, in the short term, you read the call to question, and if you can reasonably infer that the other side is on notice that litigation is pending, it opens up the floodgates to allow me to offer all sorts of things to try to make it work itself out. And if it doesn't happen, I'm going to be protected. As long as it doesn't also go to bias or prejudice or undue delay or obstructing a criminal investigation. That's really the only place where this particular rule, Rule 408, becomes problematic. Otherwise, it's relatively straightforward. Again, much like 406 is reading comprehension for habit, 408 is reading comprehension for the existence of litigation. When does it get hard? When I take 408 and I put it together with 409. Because now, 409 furnishing, promising to pay, or offering to pay is not admissible to prove liability for the injury. Yes?
Just back and forth real quick for just a second.
Sure.
You said that they were talking about pending litigation. Is that just in the definition of being involved in negotiation? Because I didn't see it in the rules, so I just wondering where that.
That's exactly how it comes. The idea is like this. Negotiation for purpose of the evidentiary rules under 408 does not apply if litigation is not pending. And the policy concept behind it is that we will give this broad latitude to lie, to say things that we don't truly believe are true, because it drives the engine of compromise at the lowest level possible, at the smallest cost to society. Just like, how many of you have taken a negotiation class or an arbitration class? One of the things you learn in negotiation class is what? It's okay to lie. Lawyers lie all the time. It's how you lie that makes a difference. Same thing in professional responsibility. The right to be honest to parties. 4.1, truthfulness in dealing with others, is completely subservient to your duties to your client. So sometimes it's in your client's best interest to lie, as long as you don't do it in certain situations. It's in lining up those rules where they overlap statutorily that you find some interesting things. No, I won't go down that rabbit hole. I could teach PR for a moment, but it's probably not necessary, so I'm not going to do it. You had a hand up. Somebody had a hand up over here. No? We good? So what's the difference when I get to the offer to pay medical expenses? When I offer to pay medical expenses, and as part of the offer to pay medical expenses, I also admit liability for the injury. So something happens on my property, I come running up to you and say, I'm so sorry this happens, let me pay your hospital bills. I'm so sorry this happened, let me pay your hospital bills, is not an admission of liability, it's just an offer to pay medical expenses. And under 409, it's not admissible to prove that I'm liable for the injury. But if I said, I knew that was broken and I haven't had a chance to fix it yet, I'm so sorry you were hurt, let me pay your hospital bills, the I'm so sorry you were hurt, let me pay your hospital bills would be accepted out and the jury wouldn't hear it. But the I knew that was broken, I'm so sorry that it hurt you, is an admission of liability made when there was not yet pending litigation. So, I can admit liability when there's not yet pending litigation under medical expenses, and the admission of liability would be admissible. So how does this get complicated? I admit liability accompanied with a desire to pay medical expenses when litigation is already pending. And the answer is, I can't sever it like I can under 409, and none of it would be admissible. Because the court says the intent to pay, the offer to pay medical expenses was not an offer to pay medical expenses. It was an attempt to compromise, to negotiate a conclusion to the litigation. And it extends the umbrella protection of 408 to 409 when the offer to pay medical expenses are made after litigation is pending. What does this mean for you? It means never admit liability when you offer to pay someone's medical bills after they're injured on your property, and never offer to do anything for anyone until after they sue you. Because if you say it before litigation is pending, it's going to be admissible as what? Admission by a party opponent. I want you to think about that for a moment, because the evidentiary rules drive you, if you have knowledge of them, to really just be a bad person and to not accept personal responsibility for anything, because you know that if you accept personal responsibility, you may very well be held liable. Yes?
So in a 408, the admission is not severed?
It's not severed, and neither one's admissible.
Okay, but under 409, it is severed and the admission is admissible?
As long as litigation is not yet pending. Because if I make an offer to pay medical expenses while litigation is pending, it is going to be treated as a 408 offer to settle the case and not a 409 offer to pay medical expenses.
Okay,
So much like 404 and 608 overlap each other for character, 408 and 409 and occasionally 407 overlap each other in negotiations. Wherever I have multiple evidentiary rules overlapping each other, I am almost guaranteed, if I'm taking a multiple choice test, to see those sorts of rules. Because the examiner can test multiple concepts in one question. And if the question is written appropriately, it can be very hard or it can be very easy. The exact same question, just changing a couple of words. So that's why I take the time to sort of lecture about this one. Now, if I look at 410 and 411, rules which we've almost talked about not at all in class. If you offer to plead guilty in a criminal case and then you withdraw from the plea, they can't admit anything that you said in the offer to plead guilty. Why? Because that would obviate what? The privilege against self-incrimination. It just doesn't make sense, and we don't allow it. That's relatively simple. Liability insurance. I want you to look at that language there at the end of 411. And I want you to think about what I told you for 407, for subsequent remedial measures. Just as we won't let just as we won't let actions to remove a danger from the public to be admissible to prove liability under subsequent remedial measures, we also will not allow evidence of insurance to prove that a person acted negligently or wrongfully. But if bias, prejudice, ownership, or control is at issue, we can get in information about that policy for those purposes. Now, this is, of course, the holy grail of plaintiff's attorneys, right? Plaintiff's attorneys want the jury to know that the defendant is insured and that the defendant's not going to be hurt, the insurance company's going to be hurt. Because that makes it less personal, that makes it less painful. And who amongst you here really loves your insurance company? I have USAA, so I'm perfectly happy with it. I hate my homeowner's policy, but I pay about $12,000 a year in homeowner's insurance.
You can get out of flood zone.
No, I don't need a quote. I have $1 million house. You know, I've got about 5,000 square feet. It's just that expensive. And it's 100 years old. But I hate my homeowner's insurance policy. And I could use a quote, but I don't have the time right now. People's trust is after me all the time for that. Yeah, exactly. And I don't trust anything that has the word people in it. You know, I'm very proud of something. Do you know what I got this week? I got a letter from Barack Obama asking me why I don't give him money anymore. And then I got a letter from the Republican National Committee asking why I was leaving the Republican Party. I'm a registered independent. I have somehow managed to convince both the Democrats and the Republicans that I think they're both full of crap. And I haven't even affirmatively done anything. I thought that was a pretty good day. Now, I've pointed out the liability stuff. I've talked about those rules, 407, 408, 409, 410, and 411. Those 4 or 5 rules, I'll tell you right up front on my exam, are going to result in at most anywhere from 3 to 5 questions, and that's it. Not much. Not much. But let me be a mathematician for you for a moment, right? At this law school, I have a required grading curve. And if I want to deviate from the curve, I have to ask permission from the associate dean. And I have to show good cause to do so. That means that you guys are going to take this multiple choice test. And out of 60 questions, there's going to be a standard mean right in the middle. And it's going to be somewhere between 35 and 40 questions correct out of 60. That's the average. 35 to 40, might be 45 this year, who knows. And then there's going to be a standard deviation. It's going to tell me how many points separate each deviation grade, right? I have had times when the mean of the standard deviation, 2 points, 3 points, 4 points. Well, if it's 2 or 3 points, because you as a class have a flat curve, whether or not you can give me the right answers as these little pick-a-yoon questions, pick-a-yoon meaning something small that's really not important normally, may determine whether you get a 3.25 or a 3.0 or a 3.5 or a 3.75. And I just tell you that up front. That's not me grading. That's the law school's enforced requirement for a normative curve. How do I try to fix that to the extent possible? Again, I'll be perfectly transparent with you. What's the standard deviation for this kind of course? I think it's what, 275 to 305? Something like that. My grade point, my grade average for the class is supposed to be somewhere in that range. If you'll go back and look at my evidence class, I'm almost always right around 3.0, 3.05. What's that telling you? That I am trying to the extent that I'm allowed to give you the maximum grade that I can. Why? Because I think you deserve it because you do the work and because I want you to look as attractive as possible to the outside world when you go for employment. But it means that the one who does the most work in this class will undoubtedly get the best grade. There's just no doubt about it. That's why I go over these small rules like that. Because getting this right may help you. Why is that important to me? Because if you get 2 points more than everybody else on the multi-state bar exam, that may make the difference between you being able to practice law or not being able to practice law. And so I want to teach you to think that way while we're in our evidence class. Because I know there are real long-term benefits to it for you. If it makes you miserable now, I'm very sorry. But you knew what you were getting into when you signed up for this. 412. The thing that I want you to remember about 412 are a couple of things. Source of semen or injury, prior consensual activity with the accused, because that would go to what? A mistake of fact defense as to whether or not they thought that it was consensual sex on the time in question. Prior consensual sexual activity with other individuals does not fit into that exception. And then, of course, there's the final one, which is the constitutionally required exception. It's on the next page in the book. I can't ask you a multiple choice question on the constitutionally required exception unless I gave the language so clear that it would be a freebie point, right? But I can ask on the other 2 exceptions. And unlike other evidence classes, because I have the new case file for you for the first time, I consider 412 to be a fair game area, which normally 412 is not usually taught unless it's taught in an advanced evidence class, unless the professor just happens to be particularly interested in the dynamics of sexual assault crime from a policy reason. And then you might talk about it a great deal of time. But I have tried to teach it to you as practicing lawyers. So you ought to be able to take apart a fact pattern and tell me whether or not a piece of evidence should or should not be admissible under the 412 standard. That's why the State v. Lewis case file is in there. So that's all you really need to know from a review perspective about 412. If you have questions come up about it as you're preparing, I'm happy to talk about those. I want you to remember 413, 414, and 415 for the following reasons. Number one, Florida does not do them the same way. So this is an area where Florida and the federal courts are different. Number two, it is the propensity rule exception to the propensity prohibition of 404A. So evidence of prior sexual acts is admissible to prove conformity therewith. And we've talked about that. We've also talked about how 413 and 412 taken together might create a situation where there's potential, I'll get you just like the office, where it might present the inability of the accused to present a defense. Yes?
I just want to make sure, so when you're talking about defendant's prior wrongful sexual acts, it doesn't have to be conviction, it just has to be wrongful sexual acts.
It could be something as simple as, dude is charged with sexual assault on a woman. Case hits the papers, the prosecutor gets a phone call from dude's prior girlfriend. She says, can I come in and talk? She comes in, she talks, and says, he assaulted me in the following fashion. Blah, 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 blah. Fact 1, fact 2, fact 3. Under 413, if you find that evidence credible, i.e. admissible, such that a jury hearing that testimony from her might think that it occurred to a preponderance of the evidence standard, it can be admitted to prove his guilt in the subsequent case.
And you have to go through 404.
You go through 403, but when you go through 403, they actually apply a 404B test. So what does that mean? It means that that prior assault that the ex-girlfriend talks about must be remarkably similar to the current charged offense. So if the prior assault was a particular type of sexual activity and the current case was a different type of sexual activity, it should not be admitted under 413 for propensity, because it's a different type of perversion that he has propensity towards. The rule is not written that broad. The rule is written broadly enough that it should all come in. Under the rule, if you engaged in raincoat flashing, the fact that you're a raincoat flasher should be offered at your trial to show that you're a rapist. But that's not constitutional. And so the appellate courts have applied that narrowing restriction to it.
So what if the defendant is on trial for raping a child, but his former girlfriend, an adult, comes in and he raped her?
Well, then you would have to look at the similarities of the way in which the rape occurred, the age of the child, the appearance of the girlfriend, and the judge would have a hearing and make a determination of whether or not to admit.
It's not different because you have the child molestation before 414 and then 413 applying.
Yeah, but child molestation is child to child, not child to adult. I want you to think of it this way. There is a factual matchup that occurs with 413 for prior acts that is very similar to the factual matchup that occurs under 404B evidence. Yet when I read 413, the statute, I don't see that language anywhere, do I? It's not there. It's only been put there by case law. And that's the reason that I bring it up for you, because if you don't know about the case law, you would read a multiple choice question on 413 phenomenally broadly and let in any prior bad sexual act. And you would be wrong and you would miss it on the bar exam. You would also be wrong and miss it on my exam. And that's an interesting way in which the court saved 413 from a constitutional perspective. Now, you can think it's great, you can think it's not. In my opinion, the judges tends to move depending upon whether I like or don't like the impact of the law that they've adopted in any particular moment. All right. On Wednesday, I will go through privileges and begin to discuss impeachments. I doubt that I'll get all the way through impeachments on Wednesday, but I am sure that we will finish up impeachments on Thursday, which means next week we'll be all the way back to experts and hearsay.